So we often think about a signed release form as a good or efficient way to cover the basis and sharing information with a variety of other service providers. So if I were someone working with a victim who had the kinds of issues that we're talking about, should I be asking that person to sign a release if I wish to share information or my concerns with other practitioners or providers?
Well, you should always ask a client to sign a release if you want to discuss their information with someone else that they don't know about, because that's part of your promise of confidentiality, right? They've shared information with you. They haven't agreed to share that information with anyone else. So you need permission to sort of extend the bubble of confidentiality to other professionals before you do that. So that's just good practice always, to get a release of information when you're going to work with anyone else. It's not good practice to just sort of get a blanket release at the outset of working with a client, because that is not giving the client full information about what they're sharing and with whom and when and for how long. So it's not narrowly tailored to the situation that you need to share that information with someone. So it's better to wait until a situation comes up where you think, well, it would be really helpful for me to discuss your case with this person. Do I have your permission to do that? And then get a very narrowly tailored release to discuss this piece of information with that person. It's much more client-informed and client-centered to work that way.
What if I'm not sure that the person understands what they're signing? Again, I either know or suspect that there is dementia involved or a capacity issue, and I'm not sure that they understand what they're signing.
Well, there are ways that you can sort of interview the client to assess their understanding. It doesn't need, if you have suspicions, it doesn't need to be as straightforward as here's this release I'm asking you to sign, and they sign it. You can have a conversation with them to really sort of prod at the limits or the bounds of what that understanding is. And if it turns out that they really have no comprehension of what it is that they're signing, then you don't actually have authority to share the information, because they're not capable of giving it to you.
Any release of information from a survivor to a victim-centered advocate should always be something that is meeting the survivor's needs, and the survivors define their own needs. So it's important to remember that releases are never center-centered. Releases are always survivor-centered. And there's some debate about whether or not releases should always be survivor-initiated. In other words, some folks working in this community will say that releases should only be happening if a survivor says, I want you to share information for me. What do we need to do to make that happen? But other folks say it's possible that an advocate just knows more about what's possible. So an advocate is in a position to make a suggestion. Would you want me to share this information for you? Would that meet your needs? Would that help you? And then a survivor might say, yes, it would. I never would have thought to bring that up. And I think both of those things are appropriate. But if you have a survivor who is not in a position to ask you to do anything because of capacity issues in that moment, then releases won't come up, because they're not asking you to share information to meet a need for them.